Welcome! In this explainer, we're going to tackle a really fundamental question in business law. What exactly is a company? We'll be using India's Companies Act of 2013 as our guide to see how the law actually creates and thinks about these incredibly powerful economic engines. So, here's what we've got on the agenda. We'll kick things off with the main rulebook for companies. Then we'll try to pin down what a company legally is. After that, we'll dive into the absolute core concept, the separate legal entity. We'll also cover its other key features, and then wrap it all up with the most important takeaways. All right, first things first, let's talk about the rulebook. You see, every single company in India has to operate according to the rules laid out in the Companies Act of 2013. This law is really the bedrock for everything else we're going to discuss. Now, you might think this was just a little tweak, but no way. This act was a complete overhaul of the old 1956 version. The economy both in India and globally had changed so much. The whole point was to modernize everything, to improve how companies are governed, make the regulations simpler, and give investors better protection. Okay, so who exactly has to follow these rules? Well, the short answer is pretty much everyone. Its reach is huge. We're talking about standard companies, of course, but also specialized ones like insurance and banking, companies that generate our electricity, and even other corporate bodies that the government says are included. You can really think of it as the central nervous system for all corporate law in the country. All right, let's get to the real head-scratcher here. When the law uses the word company, what does it actually mean? It sounds like a simple question, but the legal answer is pretty mind-bending and honestly kind of fascinating. And, this classic quote from Chief Justice Marshall just hits the nail on the head. A company isn't something you can physically touch or see. It's a concept, a legal creation that only exists because a piece of paper, the law, says it does. It's an idea brought to life. And this is where it gets really interesting. On one side, you've got Professor Haney, who gives us a great description by listing a company's features. But then you look at the actual law, and the legal definition is, well, kind of useless on its own. It basically says a company is a company. Thanks for nothing, right? This tells us that to really get it, we have to do what Professor Haney did and look at its characteristics. And that brings us to the single most important idea in all of corporate law. Seriously, if you take away just one thing today, let it be this. A company is what's called a separate legal entity. This is the absolute foundation that everything else is built on. So what does that mean? It means the law treats a company like its own person, totally distinct from the people who own it, the shareholders. The company can own a building, it can have its own bank account, it can sign a contract, all in its own name. It's not the same as its owners. Look, theory is one thing, but a real-life story really drives the point home. And there's no better example than the famous Macora case. It shows just how seriously the law takes this idea of separation between an owner and their company. So picture this. You've got a guy, Mr. Macora. He owns a timber company and basically all of the shares. He decides to insure the timber, but he makes a critical mistake. He takes out the policy in his own name, not the company's name. Then disaster strikes. A fire burns all the timber down. When he tried to claim the insurance, the court said no. Why? Because Mr. Macora and his company were two different legal persons. The timber belonged to the company, so he had no legal right to insure it himself. So, you see, the ripple effects of this one idea are absolutely massive. The company owns its own assets. It can sue someone or be sued in its own name. The owners can even sign contracts with the company they own. And maybe most importantly, the company's debts are its own problem, not the personal problem of its owners. And that leads us perfectly into its other key features. All right, so if a company is its own separate person, what else can it do? Well, this core idea gives it some pretty cool legal superpowers, which is a great way to think about these characteristics. First up, think of a company as being basically immortal. This is called perpetual succession. It means that the owners can come and go, they can sell their shares, they can even pass away, but the company itself just keeps on existing. The only thing that can kill a company is a formal legal process. And if you think that's just a theory, get this. There was a real case where all 7 members of a private company died together in a plane crash. So, did the company die with them? Nope, because the company is its own legal person. It continued to exist, even though every single one of its owners was gone in an instant. Okay, this next one is a huge deal, and it's probably a big reason you might start a company yourself. It's called limited liability. In simple terms, it means if the company racks up huge debts, the creditors can't come after the personal assets of the owners. Your house, your car, your personal savings, they're safe. You're only on the hook for whatever you invested in your shares. It's a massive protection that encourages people to invest and take risks. So we keep calling it an artificial person. It's created by law, right? Not born. And because it's not a real human being with a brain and hands, it needs actual people, we call them directors, to be its agents, to make decisions and act on its behalf. And this is a great way to think about it. What can this artificial person do, and what can't it do? Well, it can do almost anything a real person can do in business: buy property, borrow money, go to court. But it can't do things that require a body or a soul. It can't get married, it can't be a doctor, and you can't throw a company in jail. So, how does an artificial person sign a contract? Well, for the longest time, the answer was something called a common seal. It was basically an official stamp, the company's formal signature. But let's be honest, in the modern world, that's a bit of an ancient concept. And so, things have moved on. As of 2015, that clunky seal is totally optional. If a company doesn't have one, it can make a document official with the signatures of 2 directors or 1 director plus the company's secretary. It's just a much more practical and modern way of doing things. Okay, phew, we have gone through a lot. So let's take a breath and boil it all down to the key things you absolutely need to remember. This is the stuff that really matters. So think of it like this. This is the company's DNA. 1, it's a separate legal entity. 2, it has perpetual succession, meaning it's immortal. 3, it offers limited liability to protect its owners. 4, it's an artificial person created by law. And 5, its official signature, the common seal, is now optional. These 5 characteristics are what make a company, well, a company. And that brings me to my final question for you, a really big one to think about. This whole massive, complex world of corporations all comes down to one simple legal trick: creating an artificial person with its own identity. So the question is, how does that one powerful idea shape the entire modern economy as we know it? It's a huge concept, right? And it really is the engine of our economy. Anyway, that's it for me for this explainer on what a company is. Thanks so much for joining me, and I really hope you have a clear understanding now of this absolute cornerstone of the business world. Have you ever stopped to think about what a company really is? I mean, it's not just an office building or a cool logo. In the eyes of the law, it's something way more interesting, way more powerful. Today, we're going to pull back the curtain on something called the corporate veil. It's this legal shield that separates a business from its owners, and trust me, it's the bedrock of pretty much all modern business. So let's just kick things off with a question that sounds, well, a little weird. Is a company a person? I mean, it can't have a favorite movie or feel hungry, right? But legally, the answer is a huge, resounding yes. And once you really get your head around this idea of corporate personality, everything else we talk about is going to click right into place. So here's our game plan. First, we'll get a handle on what the corporate veil actually is. Then, we're going to take a little trip back in time to the one single court case that basically created this whole idea. After that, we'll look at what it takes to lift the veil. And finally, we'll dive into the specific times when the law decides to peek behind that curtain. All right, let's dive into the concept itself. If you want to understand how modern business works, you absolutely have to understand the corporate veil. Think of it as rule number 1. So what is this veil? At its core, it's a powerful legal idea that says a company is its own person. It is completely separate and distinct from the people who own it, the shareholders. That legal well of separation, that is the veil that stands between the business and the people behind it. The best way to picture it is as a legal shield. So if the company goes into debt or if it gets sued, that shield protects the personal stuff of the owners. We're talking their houses, their cars, their savings. The company might be in hot water, but they personally are safe. And this is a huge, huge deal. It's what gives people the guts to invest their money and take the risks you need to start new businesses in the first place. But an idea this revolutionary doesn't just appear out of thin air. Nope. It was actually forged in the fire of a single landmark legal battle that completely changed the world of business forever. And that case is Solomon versus Solomon and Company Limited. Before this case, the line between a business owner and their company was kind of blurry. This case came along and drew a very, very clear line in the sand.
So here's the story in a nutshell. You've got this guy, Mr. Salomon. He sells his successful business to a brand new company that he just created. The only shareholders were him and his family. He also loaned this new company a bunch of money, which made him a secured creditor. All that means is that if the company went belly up, he was first in line to get paid back. And, things went wrong. The company failed. The other creditors were absolutely furious. They argued that Salomon the guy and Salomon the company were really the same thing, and that it was a total sham for him to pay himself back before anyone else.
But the court saw it differently. In a historic ruling, the House of Lords dropped this bombshell of a quote. They said, the company is, at law, a different person altogether from its members. And that was it. Even if one person owns almost all the shares, the company is still its own legal entity. Mr. Salomon, the man, was separate from Salomon & Co. Ltd., the company, period. Now, that decision created this incredibly powerful shield for business owners. But it also opened up a whole new can of worms. What happens when people start using that shield to do shady things? And that brings us to the whole idea of lifting the corporate veil. So the big question becomes, is this shield unbreakable? I mean, can you really just hide behind it no matter what? Because if it was totally absolute, it would be the perfect tool for fraud. The answer the courts came up with? Nope. It's not unbreakable. This is what we call lifting the corporate veil. It's that moment when a court says, okay, we're going to ignore the fact that the company is a separate person for a minute. They pierce right through that shield to look at the reality of who's actually pulling the strings. And when that happens, suddenly the owner's personal assets are right back in the firing line. So what does it take for a court to do something that drastic? It's not something they do lightly, that's for sure, but there are a handful of pretty clear situations where that shield is coming down. Okay. We're going to walk through the 5 big scenarios. Courts might lift the veil to figure out a company's true character. Think wartime. They'll definitely do it to protect government revenue when someone's trying to dodge taxes. They'll do it if a company was set up just to avoid a legal duty. They'll also look through it if a subsidiary is basically just a puppet for its parent company. And the big one, they'll lift it to prevent fraud or other crimes. Let's break them down. First up is determining a company's true character. Now, a company itself can't be your friend or your enemy, right? But imagine it's wartime. A court might lift the veil to see who is actually controlling the company. If it turns out the people in charge are from an enemy nation, then the company itself can be legally classified as an enemy company. Next, and this is a really common one, is protecting tax revenue. Check out this classic case. This wealthy guy created a whole bunch of shell companies just to hold his investments. He had the companies pay him his income back, but he called them loans, all so he could avoid paying taxes. The court, they weren't fooled at all. They called the companies a total sham, lifted the veil, and made him pay the taxes he owed on his real income. The veil also gets lifted when a company tries to wiggle out of its legal duties. In one instance, a company wanted to pay smaller bonuses to its employees. So what did it do? It created a brand new subsidiary, a smaller company it owned, and moved its most profitable assets over there. This trick made the main company's profits look way smaller on paper. The Supreme Court saw right through it, lifted the veil, and treated both companies as a single entity to figure out the real bonus that was owed. You know, sometimes a subsidiary company isn't really an independent business at all. It's just an agent or like a puppet for the parent company. For example, there was a case where a transport company set up a subsidiary just so it could apply for some licenses that it couldn't get on its own. The court looked at the whole setup and said, nope, you're one single business unit, and threw out the application. And finally, we've got the biggest, broadest category of all, fraud or improper conduct. This is basically the catch-all. If a company is created for any kind of illegal purpose, to trick creditors, to get around a law, or for any other shady reason, a court will not hesitate for a second to lift that veil and hold the people behind it responsible. So let's bring this all home. What's the big takeaway? The fundamental idea is that a company is its own legal person, and it's protected by this corporate veil. That shield is absolutely vital for business and for the economy. But, and this is the key, it is not absolute. When that shield is being used not to encourage business, but to deceive, to defraud, or to escape justice, the law is going to step in, lift that veil, and look at the reality of who is really in control. And that, right there, is the central balancing act of all of company law. The corporate veil is essential. It encourages the kind of investment and risk-taking that fuels our entire economy. But it can also be abused. And that leaves us with the ultimate question for courts and for lawmakers. Where exactly do you draw the line between a legitimate corporate shield and just a convenient place to hide?
When we say the word company, what are we really talking about? It's not just one single thing. Think of it more like a set of architectural blueprints. Under India's Companies Act of 2013, there are a bunch of different designs you can choose from, and each one is built for a specific purpose, a certain scale, and a different level of risk. So let's figure out how to read these blueprints together.
Okay, so here's our game plan. We're going to break this down into 5 key areas. We'll kick things off with liability, which is kind of like your financial firewall. Then we'll look at how the number of members can completely define a company. Third, we'll get into the power dynamics and map out corporate relationships. After that, a quick look at some other important types, and then we'll wrap it all up by talking about why picking the right structure is so important. All right, let's start with the biggest, most fundamental question any business owner has. If things go south, is my own money on the line? This is all about liability, and it's the first major way we classify companies. Now, this right here describes the most popular business structure by a long shot. In a company limited by shares, you've got a solid wall between the company's debts and your personal bank account. Your personal risk is capped at whatever amount you still owe on the shares you own. So if you've paid for your shares in full, that's it. You owe nothing more, no matter what debts the company gets into. It's the go-to for a reason. It gives you protection without being super complicated. This one's a little different. You'll often see it with clubs, charities, and other nonprofits. See, here, members don't really buy shares. Instead, they give a promise, a guarantee, to chip in a specific amount of money, but only if the company has to be liquidated. The key thing to remember is this money isn't for day-to-day business. It's just a safety net for when things are winding up. So, what's the real difference between these two? Well, it all comes down to when you might have to open your wallet. With shares, the company can ask you for any unpaid amount at any time, to fund its operations. But with a guarantee, that call for cash only comes if the company is shutting its doors for good. It's a huge difference in the timing and the whole purpose of that financial promise. And finally, we have the high-stakes version, the unlimited company. And just like the name says, there is no firewall, zero. If the company can't pay its bills, the members are personally on the hook for everything. Their homes, their savings, it is all on the table for the company's creditors. This structure is pretty rare, and for a very obvious reason. The personal risk is just massive. Okay, next up, let's look at companies based on a really simple question. How many people own it? Because the answer completely changes the company's DNA, taking it from a solo act to a massive public enterprise. The 2013 Act gave us this absolutely brilliant idea to really encourage entrepreneurship. An OPC lets a single founder, like a consultant or a creative freelancer, get all the main benefits of a company, like limited liability, but without the headache of finding partners or dealing with a ton of paperwork. It's kind of like being a solo artist with the full backing of a major record label. A private company is built to be closely held. Its internal rules do 2 really important things. First, they make it harder to sell shares to just anyone. And second, this is crucial, they put a cap on the total number of members. This structure also isn't allowed to ask the general public for money, which keeps the ownership all within a smaller select group. And here it is, the magic number, 200. That is the absolute legal ceiling for members in a private company. Now, the law is pretty smart about this. It doesn't count current or even former employees who got shares as part of their job. And that allows for things like employee stock options without accidentally breaking that 200-member rule. So a public company is basically everything a private company is not. There's no limit on how many members it can have. Its shares are meant to be bought and sold freely, say on a stock exchange, and it can raise a lot of money by asking the general public to invest. This is the blueprint for those really big companies that need access to a ton of capital. Companies don't exist in a vacuum. They often own pieces of each other or influence each other's decisions. So our next way of classifying them is by looking at these power dynamics, mapping out the relationships between different companies. Think of this one like a parent-child relationship. The holding company is the parent. It has control over the subsidiary, the child, in one of 2 main ways. Either it can appoint or fire most of the board of directors, or it controls more than half of the total voting power. Either way, it gets the final say on all the big decisions at the subsidiary. And this control can actually cascade down through multiple layers. So let's say company A controls company B, and then company B controls company C. Well, that means company A indirectly controls company C too. This chain can go on and on. In a scenario like this, company A is sitting right at the top of the pyramid, making it the ultimate holding company for everyone else down the line. So what happens when you have influence but not, outright control? That's where the associate company comes into play. This happens when one company holds at least 20% of the voting power in another. It's not enough to be a subsidiary. Remember, that's over 50%. But it's definitely enough to have what the law calls significant influence over business decisions. It's like having a seat at the main table, but you're not the one sitting at the head of it. All right, let's do a quick fire round of some other important, more specialized company types you might run into. These are structures that are really built for very specific jobs. A government company is defined by one really simple rule: majority ownership. If the central government, or one or more state governments, or some combination of them, holds at least 51% of the company's paid-up share capital, well then, it's a government company. Simple as that. Section 8 companies are basically businesses with a soul. They're set up to promote things like art, science, education, or social welfare. Any profit they make has to be plowed right back into achieving that mission. They are legally forbidden from paying out dividends to their members. It's all about the cause. Have you ever wanted to just press pause on a company? Well, that's pretty much a dormant company. It's a registered company that's essentially in hibernation. Maybe it was created to hold an asset, like a trademark or a piece of land, or for a project that's planned for the future, but right now, it isn't doing any real business. And the law is super specific about what hibernation actually means. A significant accounting transaction is defined very, very narrowly. It excludes all the basic stuff you need to do to just exist. So you can pay government fees, maintain your office, and even issue shares to meet legal rules and still be considered dormant. Only real business deals can wake the company up. So we've looked at all these different blueprints. Why does it matter so much? Well, because the structure you choose pretty much defines your company's potential, its risks, and its entire future. Let's just quickly recap. Choosing a company structure really boils down to asking yourself 4 main questions. 1. How much personal risk are you willing to take on? 2. How many owners are going to be involved? 3. How will it connect with other companies? And 4, what is its ultimate purpose? The answers to these questions will point you straight to the perfect blueprint for your venture. And that really just leaves us with one final thought. Every structure we've talked about, from the tiny one-person company all the way to the sprawling public giant, is a tool designed for a specific job. So as you think about the business world, ask yourself this: which of these blueprints is actually capable of building the biggest dreams? All right, welcome. Have you ever wondered how a simple business idea transforms into a real, legally recognized company here in India? Well, today, we're going to break down that exact process, step by step. We'll be using the official rulebook, which is the Companies Act of 2013, to see how an idea actually gets its own legal life. It's a fascinating journey, so let's get right into it. Okay, so here's our game plan for today. First, we're going to talk about the key players. The folks who actually start the company. Then we'll walk through the registration process itself, all the paperwork. We're also going to cover what happens if you're not exactly truthful, because the penalties are pretty serious. And finally, we'll get to the big result: what it means to create a brand new legal person. All right, first up, the key players. So where does this whole thing begin? Well, it all starts with an idea, right? But in the eyes of the law, the person who really champions that idea and gets the ball rolling, they have a very specific title. Let's talk about the promoter. So, a promoter, what does that actually mean? Well, think of them as the architect of the company. They're not just the person with the brilliant idea. They're the one who's actually in charge, controlling things, and taking all the necessary steps to get the company registered. Now, the law is really clear on one thing. This doesn't include people you just hire for their professional services, like a lawyer or an accountant. A promoter is much more fundamental to the company's creation. Okay, so you've got your promoter, the visionary with the big idea. But can they do it alone? Well, that brings us to our next question. Who can actually form a company? The law is super specific about the minimum number of people you need, and it all depends on what kind of company you're trying to build. And this chart lays it out perfectly. It really shows you how flexible the law is. If you're aiming big for a public company, you're going to need at least 7 people to get started.
For a private company, which is probably the most common type, you just need 2 or more. And hey, if you're a solo entrepreneur, the law even has an option for you, the one-person company, where you guessed it, just one person is enough. It's all about providing the right structure for the right ambition. All right, moving on to the next big stage, the registration process. So you've got the people, you've got the type of company picked out. Now comes the part that sounds a bit intimidating, but it's really just a series of steps, the paperwork. This is where you formally file all the required documents with the Registrar of Companies. So step 1 is all about laying down the law. Literally. You have to file the company's 2 most important legal documents. First is the Memorandum and the Articles of Association, signed by everyone. Think of these as the company's constitution, what it can do and how it will run. Then you need a declaration from a professional, like a chartered accountant, plus a director saying, yep, we've followed all the rules. And finally, another declaration from the subscribers themselves, swearing they haven't been convicted of any major fraud in the last 5 years. It's all about starting with a clean slate. Okay, step 2 is all about transparency. It's about putting names and faces to this new company. You've got to provide a mailing address so they can reach you. Then, you need the full details of every single subscriber, their name, address, nationality, all of it. And just as important, you need the details for the first directors, including their special director ID number and their consent to actually take on that role. No hiding in the shadows here. And then, if you've done everything correctly, if all that paperwork checks out, success. The registrar gives you the holy grail, the certificate of incorporation. I love this part. You can literally think of it as the company's official birth certificate. At that moment, it's born. And along with that, it gets its own unique corporate identity number, or SIN, which is like its ID number for its entire existence. Now, this whole process is built on a foundation of trust and honesty. So that begs a pretty important question. What happens if the information you provided wasn't true? What if someone lied on those documents? Well, as you can imagine, the law takes that very seriously. The consequences can be absolutely huge. And look at how the penalties work, because it's a 2-stage thing. If you're caught providing false information during the incorporation process, the person who gave that info is liable for fraud. Simple as that. But here's the kicker. If the company's already formed and then they discover the fraud, the net gets cast way wider. Now it's not just one person. The promoters, the first directors, and anyone who signed that false declaration, they're all on the hook for fraud under Section 44(7). So we've talked about personal liability for fraud, but what about the company itself? What happens if the entire company was basically built on a lie? Well, in that case, a special legal body called the tribunal can get involved, and they have some really serious powers. And I'm not kidding, these are some heavy-duty actions the tribunal can take. They can step in and regulate the company's management. They can make the members' liability unlimited, which is a huge deal. They can literally remove the company's name from the official register, making it disappear. Or they can order the ultimate penalty. The company gets wound up, completely dissolved. It's basically the corporate death penalty. Okay, but let's get back to the good news. Let's assume you've done everything correctly and honestly. What's the result? Well, the moment that registration happens, something profound, almost magical, happens from a legal standpoint. A new legal person is born. So what is the real legal effect of getting that certificate of incorporation? I mean, it's more than just a piece of paper that says you exist, right? What does it truly create in the eyes of the law? And this quote from a famous case says it all. The company becomes a legal person separate and distinct from its members. This is probably the most important concept in all of corporate law. The second that certificate is issued, the law creates a brand new legal entity. It's a person that is totally separate from the people who own it or run it. It has its own identity. And this new legal person comes with some incredible powers. For one, it has what's called perpetual succession. That's a fancy way of saying it can exist forever, long after its original founders are gone. It can buy and sell property in its own name. It can sign contracts, it can sue people, and it can be sued all by itself. It really, truly stands on its own 2 feet in the legal world. All right, so let's do a quick recap. We've got all the way from just an idea in someone's head to a full-fledged legal entity. Let's pull out the key takeaways. So here's what you really need to remember. 1, it all starts with the promoters. They are the architects. 2, the registration process is precise. You have to file specific documents and declarations. 3,
Honesty is everything. Lying on those forms leads to serious fraud penalties. And 4, the end result of doing it right is incredible. You create a separate legal entity with its own unique powers. So you see, the law really just provides the blueprint. It gives you the tools to create something powerful and lasting out of nothing more than an idea. The real question isn't about the law. It's about what you will build with it. Thanks so much for tuning in. Have you ever really thought about how a company gets the money it needs to launch, to innovate, to grow? It all boils down to 2 fundamental ideas: capital and shares. In this explainer, we are going to unpack these concepts using India's Companies Act of 2013 as our guide. By the end, you'll have a super clear picture of how businesses are funded and, who really owns them. So here's our game plan. We're going to start with the big idea of capital, and then we'll break it down piece by piece. After that, we'll dive right into the heart of ownership, what a share actually is, and look at the 2 main kinds. Then, we'll wrap it all up with the key things you absolutely need to remember. It's really the most basic question in business, isn't it? Where does the money come from? It doesn't matter if it's a tiny startup or a massive corporation. How do they actually pay for their grand plans, their day-to-day operations, their people? Well, the answer starts with this one powerful word: capital. It's the fuel in the engine. Okay, let's jump right into section 1, understanding capital. To really get how a company ticks, we have to start with the financial bedrock it's built on, especially how the law sees it. Right. So in the world of company law, when we say capital, what we almost always mean is share capital. And it's so important to get this. This is not a loan. It's money that shareholders have put into the company in exchange for a slice of the pie, for a piece of ownership. Every single rupee someone contributes means they own a tiny fraction of that company. But here's the interesting part. Capital isn't just one static number. It's actually a series of different classifications that kind of tell the story of a company's fundraising journey. And honestly, the best way to visualize this is to think of it like a funnel. This funnel has 5 distinct stages. As we work our way down from the widest part at the very top, we're getting closer and closer to the actual spendable cash the company has in its bank account. So let's start at the top. Okay, so at the very top of our funnel, we have authorized capital. Just think of this as the legal ceiling. It's the absolute maximum amount of money a company is even allowed to raise by selling shares. This limit is literally written into its founding document, the Memorandum of Association, and you can't go over it without a whole formal legal process. Now, just because a company can raise a certain amount doesn't mean it will. From that maximum authorized pool, the company decides how much it wants to offer to investors right now. That part is called issued capital. So for instance, a company could be authorized to raise 100 crore, but for now, it only decides to issue 20 crore worth of shares. Moving down the funnel, we get to subscribed capital. This is the amount of the issued shares that people, investors, have actually put their hands up and agreed to buy. So in our example, if the company issued 20 core in shares and investors said, yep, we'll take 18 core of that, then 18 core is the subscribed capital. Now here's the neat little detail. A company might not ask for the full price of a share all at once. It could sell a 10 rupee share, but only ask for, say, 5 rupees up front. Called up capital is the total amount the company has officially requested or called up from all the people who subscribed. And that brings us to the very end of our funnel, the most important part, paid up capital. This is the real deal. It's the actual cash that has physically landed in the company's bank account from its shareholders. It's the bottom line, the money the business can actually use to operate and grow. Okay, so we've seen how capital flows down that funnel. Now let's zoom in and look at the actual building blocks of that capital, the individual shares themselves. What exactly is a share? What does it really represent? This quote from a famous old case just nails it. A share isn't just a pile of cash. It's a bundle of rights. It's your stake, your interest in the company, in its assets, its profits, and how it's run. The price is just how we measure that interest. The Companies Act is actually really clear about what a share is legally. First, it's defined as movable property. Just like your car or a book. That means you can sell it or give it away. And second, to keep track of all this property, each physical share certificate has to have its own unique serial number. All right, this leads us to a super important point. Not all shares are the same, not by a long shot. Companies can issue different types of shares that come with totally different rights, and understanding this difference is, well, it's key to figuring out a company's whole strategy.
So under the Companies Act, share capital is basically built on two main pillars. You've got equity and you've got preference. It's probably best to think of them as two different classes of ownership, and each one has a very different balance of risk and reward.
The name of the game here is preference. Basically, who gets paid first? As you can see in this table, preference shareholders are first in line. They get their fixed dividend before a single rupee goes to equity shareholders. And if the company ever winds up, they get their original investment back first, too. Now, the trade-off for all that safety? They usually don't get to vote. Equity shareholders, on the other hand, take on more risk for a shot at bigger, variable returns and control of the company through their votes.
So you could say that equity shares are the real risk-taking capital. These shareholders are the ultimate owners. They're fully invested in the company's future, for better or for worse. The law also gives companies a bit of flexibility here, allowing them to issue equity shares with different or differential rights.
And this isn't just a textbook thing. A perfect real-world example is from Tata Motors. They issued Special A equity shares that gave investors a bigger dividend payout. So what was the catch? Well, their voting power was drastically cut. It's a really smart way to attract investors who care more about income than about having a say in running the company. Phew. Okay, we've gone all the way from the big picture view of capital down to the nitty-gritty details of different share types. Now let's just lock in the most important things you need to walk away with. So, if you remember anything, remember this. 1. Capital is a funnel, starting with the maximum authorized amount and narrowing down to the actual paid-up cash the company can use. 2. A share isn't just money, it's a bundle of rights that represents your ownership interest. And 3. The huge difference between equity and preference shares. Equity means ownership, risk, and control. Preference means safety and getting paid first.
And I'll leave you with this to chew on. The mix of capital a company chooses to raise can tell you a whole lot about its strategy, its appetite for risk, and the promises it's making to its investors. You see, a company loaded with equity shares might be signaling a high-growth, all-or-nothing plan, while a company with a lot of preference shares might be broadcasting stability. The structure itself tells a story.
Welcome. In this explainer, we're going to break down one of the most fundamental documents in all of business law, the Memorandum of Association, or as you'll often hear it called, the MOA.
So what is an MOA? Well, a great way to think about it is like the architectural blueprint for a company. It's the foundational document that sets out its identity, its purpose, and, this is key, the absolute limits of its power. In short, it dictates everything the company can and cannot do.
All right, here's what we've got on tap. We'll start with the why the MOA is so essential. Then we're going to dissect its anatomy, piece by piece. After that, we'll get into what happens when a company steps outside its own legal boundaries.
So, first up, the company's essential charter. At its core, this is all about creating clear, public boundaries for everything the company does.
The MOA basically lays out the objects of the company, its purpose, and the scope of its activities. And here's a crucial point. It's a public document. That means anyone, whether you're a potential investor or just a supplier, is presumed by law to have read it and to understand the company's official powers. So as you can see, the MOA really acts as a shield, protecting all the key stakeholders. For shareholders, it's a guarantee that their money is being used for the agreed-upon purpose. For creditors and partners, it provides a clear, public record of what the company is legally allowed to do.
Okay, so what's actually inside this all-important document? Well, every MOA is built around 6 key clauses that together paint a complete picture of the company.
These 6 clauses are mandatory. You've got the name clause, registered office, object, liability, capital, and the association clause. Each one defines a really critical aspect of the company's identity and its legal framework. Let's break them down.
The first 3 clauses are basically the who, where, and what. The name clause is simple. The company name must end with limited or private limited. The registered office clause just tells you which state the office is located in, but the object clause, now that one's a big deal. It defines the very purpose of the company and all of its business activities. This clause is what draws the line in the sand. Next up, we have the clauses that deal with the money, or the how much and who. The liability clause states if the member's liability is limited by shares or by a guarantee.
The capital clause details the authorized share capital. And finally, the association clause is where the initial subscribers formally confirm their intention to form the company.
Now, not all companies are the same, right? So the law provides different templates or tables for the MOA depending on the company's structure. As you can see, whether it's a company limited by shares or one limited by guarantee or even an unlimited company, there's a specific form of MOA it has to follow.
So, what happens when a company ignores its own blueprint? What if it acts beyond its own boundaries? Well, this brings us to a critical legal principle known as the doctrine of ultra vires. Ultra vires, it's a Latin term, and it literally means beyond their powers. It applies to any act or contract made by the company that goes beyond the powers stated in its object clause. And the consequence is severe. The act is considered wholly void, not just voidable, but void. In the eyes of the law, it's as if it never happened. Now, this slide highlights an absolutely critical distinction. If an act is ultra vires the company, meaning it's outside the scope of the MOA, it's void, period. It can't be fixed. But if an act is just ultra vires the directors, meaning the company could do it, but the directors weren't authorized, well, that's a different story. The shareholders can actually vote to approve it and make it valid. Okay, theory is great, but let's see how this doctrine works in the real world by looking at the landmark case that established it all. Ashbury Railway Carriage versus Richer. So the Ashbury Company's MOA was very specific. Their business was to make, sell, and lend railway carriages and to work as mechanical engineers and general contractors in that field. Pretty clear, right? It's all about railways. But then the company's directors made a deal to finance the construction of a railway in Belgium. Notice the shift. They weren't building railway parts. They were acting like a bank. This was a whole different ballgame. So the big question was, could financing a railway line be considered part of their business as general contractors? The company argued it could, and the shareholders even voted to ratify the whole deal. But was that enough to make it legal? Well, the court's decision was definitive. They said the contract was null and void. The judges ruled that the term general contractors had to be interpreted in the context of the company's main business, which was mechanical engineering. Since financing a railway wasn't mechanical engineering, the contract was deemed ultra vires and therefore totally void. This case really cemented the serious consequences of an ultra vires act, which are strict and pretty unforgiving. So let's summarize the key rules here. This is the harsh reality. A company can't be sued on an ultra vires deal, but it also can't sue anyone else on it either. And as we saw with Ashbury, even with unanimous shareholder approval, you can't breathe life into something that was void from the very beginning. It's a legal nothing. So if you remember one thing, make it this distinction. The boundary is the MOA itself. If the company crosses that line, the act is void. If a director crosses a line but stays within the company's overall powers, the shareholders can fix it. So where does that leave us today? Well, while the doctrine of ultra vires is still on the books, its teeth aren't quite as sharp. That's because modern company law makes it much easier for a company to simply amend its MOA. With a special resolution, a company can alter its object clause, effectively just moving the goalposts. And that leaves us with a final thought. In today's fast-changing business world, where companies need to pivot and evolve constantly, does this 150-year-old legal boundary still protect investors, or does it just get in the way of modern innovation? Something to think about. Thanks for watching. You know, every company has an internal rulebook, right? But what happens when those private rules crash into what the outside world expects? Well, today we are diving deep into the legal ideas that control how a company works on the inside and how it deals with people on the outside. We'll look at what you really need to know before you ever sign a contract with one. Let's get right into it. So, here's our roadmap. First, we're going to peek inside the company and check out its private rulebook. Then, we'll see how that document stacks up against its public-facing constitution. After that, we'll flip the script and look at things from your perspective, as an outsider. We'll cover the pretty strict responsibilities the law puts on you, but also the crucial legal shield that protects you. And finally, we'll find out when that shield can break. All right, let's kick things off with Section 1, the internal rulebook. This is really the nuts and bolts of how a company runs day to day, and it has a formal name, the Articles of Association, or just the AOA. The most important thing to get here is that the AOA is basically the company's operating manual. Seriously, it's the how-to guide for just about everything, from how they appoint directors and run meetings to how they issue new shares. It manages all the internal machinery and spells out who has the power to do what.
You know, this old quote from Lord Cairns just nails it. He says the articles are subsidiary to another document, the Memorandum. And that word is key. The AOA doesn't set out the company's big, grand purpose. Instead, it takes that purpose and builds the step-by-step framework for how they're going to achieve it. It's all about the execution.
So this brings us to a really important comparison. To get a handle on the AOA, you have to see it next to that other big document, the Memorandum of Association, or MOA. And the easiest way to think about it is like this. If the AOA is the company's rulebook, then the MOA is its constitution. Okay, this table really breaks it all down for us. Let's start with objectives. The MOA defines what the company is supposed to do, its whole reason for being. The AOA then explains how they're going to do it. Then, for relationship, the MOA faces outward. It defines the company for the rest of the world. The AOA, on the other hand, faces inward. It's all about managing internal business. Now, what about changing them? Well, altering the MOA is a huge deal, kind of like trying to amend a constitution. The AOA is way more flexible, and this last one is the biggie, scope. If a company does something that goes beyond the powers in its MOA, that act is completely void, period. But if they just break a rule in the AOA, well, that can often be fixed and approved by the shareholders later on.
All right, so now we get the internal documents. But what in the world does this mean for you, an outsider who wants to do business with a company? This is where the law introduces a very important and, frankly, kind of harsh rule.
It's called the doctrine of constructive notice. And here's the deal. Because a company's MOA and AOA are public documents, the law assumes you have read them. And not just read them, but that you've understood them. It doesn't matter if you actually have or not. The law basically says, hey, the information was there. It's on you.
So the logic goes like this. 1, these documents are public record. 2, because they're public, you are legally presumed to know what's in them. And 3, that means you can't sign a contract that goes against the company's MOA and then turn around and claim you had no idea. Ignorance is no excuse. If the deal is beyond the company's powers, it's your loss.
But wait a minute. This creates a huge problem, doesn't it? Okay, fine. You can read the public AOA. But how could you possibly know if the company actually followed its own internal rules for a specific decision? I mean, did the board hold the right meeting? Did they get enough votes? It's impossible for an outsider to check on that stuff.
And that's precisely why the law created a counterbalance. This is an absolutely critical protection for outsiders, and it's known as the doctrine of indoor management. You might also hear it called the Turquoise rule. And what it says is, look, while you're expected to know what's in the public documents, you are not responsible for being a detective and policing the company's internal affairs. You get to assume that all those internal procedures, the meetings, the resolutions, the approvals, have all been handled correctly. The famous case that gave this rule its name, Royal British Bank versus Turquoise, illustrates this perfectly. So a company's articles said its directors could borrow money, but only if they passed a specific internal resolution. They went and got a loan from a bank, but they never actually passed that resolution properly. When the company couldn't pay the loan back, it tried to get out of it by saying the directors didn't have the authority. But the court sided with the bank, saying the bank had every right to assume that all the internal paperwork was in order. And the court's ruling established this really powerful and simple principle. The company's indoor affairs are the company's problem. Outsiders aren't expected to peek behind the curtain. As long as a deal looks legitimate on its face, you're protected.
But, and this is a big but, this protection is not a blank check. The law is always about balance. And there are some very specific situations where you, the outsider, actually lose the protection of this doctrine. So let's look at when that powerful shield can fail.
There are 3 main exceptions we need to talk about. First, if you actually knew there was an internal problem. Second, if the whole deal was so suspicious that it should have raised some major red flags. And third, in cases of outright forgery. Let's start with knowledge. This one's pretty simple. You can't claim you assumed everything was fine if you actually knew it wasn't. In the Howard versus Patton Ivory case, some directors lent money to their own company. But here's the thing. They knew perfectly well they hadn't gotten the shareholder approval they were required to get. So they couldn't turn around and use the Turquoise rule to protect their investment because they were aware of the problem from the get-go.
Okay, the second exception is suspicion. The law does not protect you if you choose to ignore obvious warning signs. If a deal is strange enough to make you think, that's weird, you have a duty to ask some questions. In one classic case, a person bought company property from the company's accountant. The court said, come on, that's obviously suspicious. Accountants don't normally have the power to sell off company assets, and because the buyer didn't bother to investigate, they lost the rule's protection.
And finally, forgery. This one is an absolute deal breaker. The doctrine of indoor management can protect you from internal mistakes, procedural slip-ups, that sort of thing, but it cannot magically make a forged document valid. A forgery is a total nullity. It's void from the very beginning. In the Rubin case, a company secretary forged directors' signatures on a share certificate. The court's ruling was simple. The certificate was worthless, and the rule offered zero protection.
So let's do a quick recap of everything we've covered. The AOA is the company's internal rulebook, and it operates within the bigger framework of the MOA, which is its constitution. The doctrine of constructive notice says it's on you to know what's in those public documents, but the doctrine of indoor management protects you from having to worry about a company's secret internal processes, unless, of course, you knew there was a problem, the deal was super suspicious, or forgery was involved. And that brings us to our final thought. This whole legal setup is a really delicate balancing act, isn't it? On one side, you have the need to protect companies from people acting without authority. On the other, you have to protect innocent outsiders who are just trying to do business in good faith. So the question is, how does this constant push and pull really shape modern business, from tiny startup deals all the way up to massive corporate mergers? It's something to think about. Thanks for joining me.